All rise. The court is back in session. Be seated.
Okay. Good morning, and we are now ready for our second case, Miller versus LG Chem. Looks like everyone is in place and ready to proceed. So we have the timer automatically set for 5 minutes. Rebuttal, if you need something else, let us know. And we're ready to proceed. Oh, one other thing I wanted to mention in this case before I started, I know counsel had brought it to our attention that there are some sealed documents in this case, and we will all be careful not to refer to any of the confidential information in those documents. If any of us start to ask a question, the rule is always not to interrupt the judge, right? But if one of us slips and we start to say something or ask something that you think would go too far on that, please interrupt us and say so, okay? And we will revise that question.
May it please the court and counsel, my name is Sarah Willingham. My co-counsel, David Larson, and I of the Painter Law Firm represent the plaintiff appellant, Eric Miller. I was going to say something about the sealed documents, but the court did. LG Chem Limited is a global corporation that manufactures 18650 lithium-ion batteries. Plaintiff alleges that its U.S. subsidiary, LG Chem America, markets 18650s. Over 100 vape shops in North Carolina sell 18650s. The plaintiff, Eric Miller, purchased 2 of these batteries at vape shops in North Carolina. One of those batteries had a defective separator. Mr. Miller was severely injured when it experienced a short circuit and exploded in his pocket. This violent explosion is known as thermal runaway, and it essentially turns the battery into a flamethrower. Third-party discovery revealed that distributors in the supply chain of Mr. Miller's vape shops bought tens of thousands of 18650s. Also, an unknown number of 18650s are sold in battery packs for power tools and other products throughout the United States, including North Carolina. The number is unknown because the defendants refused to answer discovery about the distribution of their 18650s. In fact, the defendants have produced no documents in this case, and they have stated repeatedly that they did not sell 18650s directly to North Carolina without revealing their third-party distributors.
Ms. Willingham?
Yes.
I can, because I know that your time will be short. This case was decided by the trial court before our North Carolina Supreme Court's decision in Mucha.
Correct.
And I think also before the U.S. Supreme Court's decision in Ford.
Correct. The Ford came out after the appellant's opening briefs.
Okay.
So it is discussed in the reply brief, or I'm sorry, the appellee's briefs, and then the reply brief.
But the trial court's decision was made without the benefit of Ford.
Correct. Or I would also add Cohen versus Continental Motors of this court.
Right, which is very recent. How does Cohen or Mucha change the analysis?
I think they all support the appellant's argument that he made a prima facie case of personal jurisdiction, because at this stage that's the burden that the plaintiff had, was only to make a prima facie case. And so the first prong of that is purposeful availment. And plaintiff showed that because LG Chem, the defendants have not rebutted that they distribute 18650s in North Carolina. This case turned on the use of them, which goes to the second prong of the test, which is whether the claims arise out of or relate to the defendant's contacts in the state.
And would you be heavily relying on the "or relate to" language?
Yes. Yes, Your Honor.
Okay. And you acknowledge that that's not limitless, right?
Correct. But in this case, and I will discuss it more later, LG Chem knew that these batteries were being used for vaping devices before the plaintiff's injury and did not take steps to prevent that. They do discuss some efforts they made, and that is part of the sealed record, but they actually made changes to the battery to make them safer for vaping devices when they first learned that this was happening. And then secondly, LG Chem has other contacts in North Carolina that plaintiff presented through public records that involve lithium manufacturing companies in this state.
Let me ask one statement you just made. You're saying that they made the batteries safer because of vaping devices. Isn't it also just say that what they did, any modifications, made the batteries safer, period, in all applications?
Right.
It's not fair to say that it was related to the vaping that was the reason they changed the battery.
In Mr. Shin's deposition, which is not in this case, he was not deposed in this case, so in a 2017 case out of Texas, Mr. Shin, who is the corporate affiant in this case, he was deposed, and he said in 2016, LG Chem became aware that these batteries were being sold. They sold the batteries to what he called small agents for use in battery packs for small power tools. They learned that those batteries were being taken by those small agents and resold as individual batteries and used in these vaping devices. And they sent a corporate representative to the United States, he didn't say where, to investigate the sale of these batteries at vape shops. And in response to that, and they also had claims and court cases involving explosions and injuries, in response to all of that, they changed the separator because they thought that taking it in and out of the vaping device would cause damage and cause an explosion, and the modifications they made would make it safer. So I do think that the changes, at least those changes in his deposition, were related to vaping.
But they would also make the batteries safer generally, too. You agree with that?
I think that would require expert testimony because the way that they produce the batteries for these battery packs, these safety protections are that they're in a pack. So here they're used individually. I think the court may be correct that it would make them safer when used individually.
Have they ever sold the batteries for individual use or for consumer or retail use?
The defendants deny ever having sold or intended to sell them for individual consumers as standalone batteries or rechargeable batteries for vaping devices. I suppose they haven't said whether they sold them in that way for another device.
Am I correct that the plaintiff noticed the hearing on the LG defendant's motions to dismiss?
I believe that is correct. I know the plaintiff noticed also his motion to compel. So whether there was a first notice of hearing and then the plaintiff noticed it with that motion to compel, I don't recall. I think you're correct, though. I think the plaintiff noticed the hearing and to ask for discovery.
So if the plaintiff had simply noticed a motion to compel discovery and hadn't noticed the motion to dismiss, would we be here?
I don't know, Your Honor. It would depend on what the trial judge would do at that point if he denied the motion to compel.
Okay. Have you found any cases where minimum contacts were established and determined to be related to a claim, where the minimum contacts were based on the source of materials used in a defective product rather than the sale or distribution or the use of the final product in the forum state?
I don't recall a case where minimum contacts were found for a component of a product. But here, the product is the battery. It is the 18650. Now, the separator is a component of that we allege is defective. But the product that LG Chem manufactured and distributed is a standalone battery. 18650 refers to the size of that battery. It's a little larger than a AA battery.
I understand what other courts outside of North Carolina may or may not do, or persuasive authority only.
Right.
The appellee cites Missouri, Texas, Washington, the 11th Circuit, and the 9th Circuit on what they say is similar facts to what we have here, have refused to find jurisdiction. Do you want to comment
I can.
on those cases and why the situation here would be different
Right.
than what was present there?
Right, I can comment on those cases. So all of those cases, except for two that the appellees have given as additional authority in the recent days, were pre-Ford. So I believe that some of them would be different having the Ford decision. Also, let me find those cases.
It's on page 5 and 6 of the appellee's brief. I didn't check the timeline against Ford.
Right, they're all pre-Ford, except there are two new Texas cases that the appellees presented. I wanted to look at a couple specifically. Some of them have a different test for stream of commerce than North Carolina, and I think that's a distinguishing factor. Also, the case out of the 11th Circuit, the decision really turned on the fact that Oklahoma residents who purchased batteries in Oklahoma from Oklahoma retailers had gone to Georgia to sue. And that is an issue brought up in Ford, also the plaintiff's connection to the forum. So I believe the Davis case from the 11th Circuit is distinguishable. And then also the Walsh case from the 9th Circuit, that required a but-for test, and it said that the plaintiff had failed to demonstrate that he would not have sustained his injuries but for the company's forum-related activities.
And in Ford, that was the causation test that the Supreme Court said it can be but for causation or related to.
Correct.
So there's the related to language that could arguably expand their liability. Is that correct?
Correct.
So can you tell us how under related to, under Ford related to, how the LG's actions have, in North Carolina, have allowed it to be held in the court here?
Correct. Okay. First, I'd like to say that the unauthorized use argument that the defendants make, I don't think it applies at all to this jurisdictional question.
Let me put a caveat. If we do not agree with your stream of commerce argument, let me put that exception in there, that merely because something is put into the stream of commerce, you're liable for any possible consequence from that. If we reject that argument, then what else is left other than that?
I'd also say it's stream of commerce with no efforts to restrict the sale to North Carolina, which the defendants admitted in this case. That's one instance where they did respond to discovery. They were asked for documents, agreements, or contracts restricting the sale of 18650s from North Carolina, and they said they had none for the relevant time.
So is not restricting enough? Are we a stream of commerce plus state that requires some affirmative targeting of North Carolina as opposed to not restricting?
No, I believe that North Carolina is still a stream of commerce state. The cases Bush and Cox, Bush is from 1983, I believe, Cox is from 1992. They have that stream of commerce test. Cox actually says it was not weakened by the Asahi case. And then in Padron, which is a 2018 case, that standard is still accepted.
And I realize that it had nothing to do with products liability, but in the Mucha case, our Supreme Court held there must be some evidence from which the court can infer that in undertaking an act, the defendant purposely established contacts with the state of North Carolina specifically. And it also went on to interpret Justice Breyer's concurrence in McIntyre as holding that it's not enough to target a nationwide market with a general understanding that the product could end up in a forum, but that instead that the defendant must have targeted the forum state specifically.
Yes, and I think that goes to purposeful availments, and it also goes to Judge Tyson's question, which I still want to discuss about what is left besides stream of commerce. So first, in Mucha, I believe it was a domestic a divorce, and he was making a phone call. He had no idea that the person he was calling was in North Carolina. Here, the defendants have never denied that they sell 18650s in North Carolina or distribute them to North Carolina for use in these products. At the hearing, counsel for the defendants told the trial judge, if you have a cordless power drill, it likely contains these cells. They are specifically saying they don't distribute them for this purpose. So they're limiting the test there, as did the trial judge. So they do have knowledge that 18650s are going to North Carolina, and they have purposely availed themselves to doing business in this state. But as to their other contacts, besides stream of commerce, plaintiffs presented evidence that the LG Chem defendants had contracts with a lithium company called Livent. In 2019, they had announced a multi-year supply agreement for lithium hydroxide for multiple battery uses. And I would refer the court, that was in 2019, after plaintiff's injury, but it suggests a longer relationship. And I would refer the court to the sealed materials, which discuss relevant contacts between the defendants and North Carolina companies during the relevant time. Also, Himson Batteries is a company in Cary that makes power stations. They told plaintiff's counsel that they purchased 18650s directly from LG Chem.
If I can just interrupt, two questions. I want you to go back to what you just said about they made a denial, but that isn't enough here. Are you disputing any of the facts found by the trial court?
Yes.
Okay.
Yes. So I would say the trial court misapplied the facts.
Okay. It's an important distinction because our standard of review is different for findings of fact and conclusions of law.
Correct.
And if you're saying the trial court's findings don't support its conclusions, that's just a different analysis.
Correct. Yes. First, the trial court considered that LG Chem made efforts to restrict 18650s for use in vaping devices, and that is included in the sealed materials. But if the court would look at those sealed materials, they'll find that those efforts that LG Chem made, the only one directed towards North Carolina, happened in 2018, which is after the plaintiff's injury. And then on the public record, plaintiff produced a letter that LG Chem sent to one of the distributors in this case, a cease and desist letter, but that was also after the plaintiff's injury in November of 2017. So as to the trial court's findings, any credit that the trial court gave to those efforts, they were not timely to prevent plaintiff's purchase or injury.
Okay. You just referenced a hearsay statement from a vendor, someone, to plaintiff's counsel. I expect that we're going to hear from LG Chem's attorney that that's not competent evidence to be considered.
The court did consider it. It was contained in a declaration of Stuart Painter,
Right.
Plaintiff's counsel. The court in its order specifically said, I have considered Mr. Painter's declaration, And the second issue I want to discuss in this case, and it's a very important issue, is jurisdictional discovery. The plaintiff should have had the opportunity to present different evidence, but plaintiff did not have that jurisdictional discovery, and LG Chem did not disclose these contacts in discovery.
Let me ask, going back to Ford,
Sure.
and Justice Kagan, the causation but-for test or related to. Up until Ford, there was a but-for test. When you look at Volkswagen, Bristol-Myers, and you go all the way back through the history, I think if there's an expansion of jurisdiction, it comes from Justice Kagan's interpretation of related to. Do you agree with that?
Not necessarily. I know the language arises from or relates to has been
Well, the
there.
arises from is the but-for. That's the causation prong.
Correct.
So the related to is more than a but-for.
I would agree it's been expanded by,
Okay.
yes.
Justice Kagan also said it has quote-unquote real limits.
Correct.
And the concurrences in that opinion criticized the majority for not detailing what those quote real limits are.
Correct.
There was an analogy of a wood duck carver in Maine whose decoy ended up somewhere else and never intended for his decoy to be there, just by, quote, stream of commerce. So my question goes back, is the real limits on related to means that stream of commerce standing alone is not enough? There's got to be some other showing other than the defendant put it into the commerce. Doesn't how it showed up in the forum, isn't that relevant too? And how it got there?
I believe foreseeability is a factor, and here there was foreseeability. First, as to 18650s, they know that they're being distributed nationwide, including North Carolina. They haven't denied that. And as to LG Chem America, they've not denied marketing those batteries. And then
To the form in which they're sent, is that part of the related to? If they're only sent in battery packs for power tools and someone disassembles those and takes those out, that's stream of commerce, but is that related to? Is there a causal break, or is there some point in which the actions of third parties would absolve the defendant?
not in this case where LG Chem clearly had noticed that that's what was happening, and they didn't have they didn't cut off that line of distribution to these small agents, because I know Ford says that one of the goals of personal jurisdiction is to give a company or a defendant fair warning that they could be sued in a forum.
Do you have any authority that once a manufacturer knows or has knowledge that the product they're putting into commerce is being used contrary to the purposes for which it was designed, they have some affirmative duty worldwide to go and try to remove that use?
I don't believe they have a duty, but if they don't, they make themselves liable to litigation in those forums, because Ford said,
So where are the real limits, quote unquote, on related to? If it's just putting it out there and then not taking affirmative action once you know.
I think the company in that case can limit it. As Ford says, they can change their conduct to not make themselves liable for suit in those forums. And so I think while it might not be a legal duty, it was on LG Chem to make those changes, which they did not.
So you're saying that they could become liable for jurisdiction by doing nothing?
Yes. Putting their product in the stream of commerce, not restricting its distribution to North Carolina, and then secondly here, when they find out it's being used in an unauthorized manner, not cutting off that line of distribution, not making a change, other than to change the battery so maybe there are less explosions. And also, I don't think that that is particularly relevant to Ford or to personal jurisdiction, because there is a defense for products liability of a modification or a different use of the product. So that is available to LG Chem in this case.
But that would be a merits defense, correct?
Correct. And there are cases in other states that have rejected this same argument from LG Chem in exploding battery cases and said that's an issue for merits discovery.
So where does the limit that Judge Tyson refers to from Ford, where does that analysis end and the merits analysis begin in this case?
Here, I think the question is, did LG Chem purposefully avail itself to the benefits of doing business in this state by putting into the stream of commerce 18650 batteries, not restricting their distribution to North Carolina? That, I believe, is the test in North Carolina for purposeful availment. As to the second question, Mr. Miller's injury relates to the distribution of these 18650s, and to the extent that they were distributed in a way that LG Chem did not intend or did not authorize goes to the merits of the product's liability claim. And courts in Texas, Georgia, the Eastern District of California have rejected the same argument. And I would refer the court, it was an additional authority that the plaintiffs provided. It's the LG Chem Limmerman decision from the Georgia Court of Appeals, I think is the most recent. And it said the question of whether there was an unforeseeable misuse of the product by the injured plaintiff goes to the substantive merits of the product's liability action and can be addressed in that context. And then also in the Baca case from Texas, which is in plaintiff's addendum to his opening brief, the same type of affidavits were produced in that case as are here, almost the exact same language. And the court found that the plaintiff had made a prima facie case for jurisdiction because the LG Chem only denied that they distributed batteries for this very specific purpose. And in fact, LG Chem America admits to selling in both North Carolina and in that case, New Mexico, petrochemicals in the state. And it says that's what it primarily sells. So by using the word primarily leaves it open that there's other products that it sells within the state. And I think that is a big issue in this case, that they did not answer that question of what are their contacts to North Carolina. And the court should have allowed jurisdictional discovery. And I've gone way over my time and haven't been able to discuss jurisdictional discovery.
One thing you could do, Counselor, is rest upon the arguments made in the amicus brief.
Absolutely. Especially in this case, as the amicus say, where the plaintiff is an individual and the defendant is a corporation and the plaintiff is a stranger and has, as we've shown, has had to look at public records to try to make a record on that. Thank you.
May it please the court. My name is Chris Sterenbacher, and I represent the appellees, LG Chem Limited and LG Chem America. I always have a great plan when I step up here until I hear what the opponent has to argue, and it always changes things slightly. Let me focus on a couple of those things, and then I'll move into my argument. The first of which is that while LG Chem and LG America are just as guilty of it as the plaintiffs, in that we cite other jurisdictions for how they've ruled on these matters. But as the courts have always said, these determinations are fact-specific and jurisdiction-specific. Specifically in the last reference to the Georgia determinations, the standards are different in Georgia. In Georgia, the burden is upon the defendant to establish a lack of jurisdiction, whereas here in North Carolina, the burden is on the plaintiff. The other crucial point is that this court has a bit of evidence that was not in any of the other LG cases, and that is the affidavit that's under seal, and that's in the sealed materials at 1516. Those were considered by the trial judge in this matter. You will find in any other LG case that you look at, that information was not provided because it was not felt to be relevant. It became relevant in this case based upon the inquiries by the trial judge, and then it was submitted and relied upon by the trial judge. So the court should be aware of they are looking at information that has not been provided in those other matters. You will note, if you were to read those opinions, that that information that's found on pages 15 and 16 in that affidavit in these sealed materials is not contained therein.
Plaintiff's counsel has pointed out that the cases from Missouri, Washington, 11th and 9th Circuit that you cite on pages 5 and 6 of your brief,
Yes, Your Honor.
that these are all pre-Ford cases.
Yes, Your Honor. And then we did submit in additional, because obviously Ford came out in the midst of
In
all
March.
this. And we did then submit further opinions that were after that. But again, Your Honor, I didn't want to cut you off, but Ford is a new area, and I greatly appreciate the comments that you made during plaintiff's argument in that Ford is, as well as you noted in the Cohen case just that came out on September 7th, it recognizes that stream of commerce has been there all along, but there is a purpose of availment standard that's got to be there. And let me point out the specifics in Ford.
Is
Clearly,
purposeful availment a North Carolina standard, or is that a federal standard?
Your Honor, I would say that based upon Ford, because obviously 14th due process is a federal standard, obviously, but our laws have to comport with that. And as the courts have narrowed, we start with Cox. Cox just talks about stream of commerce. But then we get to the Cambridge decision that you were a part of, Judge Tyson. And then we get to Cohen. It is a recognition that stream of commerce is not enough. It just simply is not. Because of all the questions that you've asked, the idea being that there's a product out there, that there's a great case that says basically if you apply stream of commerce, your chattel becomes your registered agent. That just means wherever it goes, somehow you're there responsible. And this is a perfect example of why that's not due process. Because, unlike what was argued by the appellant, that there was no efforts to stop this scenario, that's not what that affidavit on page 15 and 16 of the sealed material says. It is absolutely different. If you look at the timeline of the efforts that are taken in there, in conjunction when Mr. Miller purchased this standalone cell, you will see that this cell was never intended to be in his hands.
Do you agree that Justice Kagan expanded personal jurisdiction over non-resident defendants in Ford by adding a related to standard in addition to a causation standard?
Your Honor, I have to be incredibly candid in that in preparation for my argument today, I thought it didn't matter because I looked at the facts of Ford and I know that those facts are not the facts here.
Well, we're trying to apply a principle. We had the facts. We had the facts in Volkswagen. We had the facts in Bristol-Myers. We had the facts in Goodyear. We can go, pick your case.
Correct.
But the principle of law is what we've got to apply to these facts.
Yes, Your Honor.
And so, arguably up till Ford, as was true in Continental, there was a causation standard,
The but for.
the but for. Now, because of Ford, it's or related to. And that means something more than but for, something different than but for. And Justice Kagan says real limits. She didn't say what those real limits are.
Said something about the limited sphere, I think was
Right.
in there as well.
So that's the struggle I'm having here is if we do not agree that stream of commerce is enough because related to has, quote, real limits, and there's a purposeful availment prong, you know, the plaintiff is arguing that you're doing business, your client's doing business here. They're shipping these batteries to North Carolina, all but they're in a different form, they're packaged differently. And then the question comes, if someone's taken those that are admittedly here in the state, and they're doing something with those they should not do, then that's a merits defense and not related to whether or not you can be sued legitimately here. That's as I understand their argument. And I want you to respond to that because, to me, that's the crux of the cases before us today.
Well, I think it goes a little bit further because it's not, when we're talking about a product being put into service, there's several things that are discussed about. It talks about being put into the market and going to the consumer. I think there's are key facts in this scenario that go to the jurisdictional issue and not the merits.
Okay, now Cohen, Continental supplied their parts solely through distributors. They did no direct sales.
Correct, but it was to get to a market. And what was the market? The market for people who needed those tires.
No, this was airplane parts.
I'm sorry, Cohen, you're correct. But if you do recall in Cohen, that airport part was sold to Triad, which was a North Carolina entity, and Air Care, who was servicing it, who was a North Carolina entity, as well as the expectation that Air Care used that online manual that they provided, that was provided by the defendant. Those were all the purpose of ailment. It was intended that that mechanic was going to be using that part for that purpose in North Carolina.
Now, are you denying that your client is actually shipping these batteries? Forget the format they're coming in, but are these batteries being shipped to North Carolina?
Your Honor, this record does not say, and I do not know the answer to that question. What I can say is,
So you would assert that the evidence offered by the plaintiff of all the vape shops that have these batteries doesn't establish that fact?
absolutely not, Your Honor. And here's why. If you go to, let's go to the findings of fact, right? And so that'll get me back on my argument. I appreciate that. So let's start there. Now, the standards as articulated by plaintiff in the page 19 of their brief is that competent evidence is that a reasonable mind might accept as adequate support of finding. That's the standard that you apply to the findings of fact that were entered by the trial court. As well as if you read through their brief, while they, on approximately 5 locations, indicate there's an error of fact, they don't rebut any one of them that the trial court made. And those facts that the court relied upon indicate that these cells were not designed, manufactured, distributed, advertised, or sell these lithium cells for use by individual consumers as standalone, replaceable, rechargeable batteries in electronic, cigarette, or vaping
But
devices.
if we can break that down.
Sure.
Okay, that's like a compound answer. It doesn't say these were not sold in North Carolina. Doesn't say that. It says they weren't sold for the purpose of being used standalone in vaping devices. When we get to the purpose that they were provided for, how do you respond to the plaintiff's argument that that purpose doesn't go to the jurisdictional question? It goes to the merits defense.
Because it goes to how did that cell get here? Because the findings of fact were also that in that case, they bought those cells from one of 2 vape shops. And those vape shops bought it from a series of distributors. And those distributors, all of the chain of evidence that chain of supply, as noted in the record, LG Chem or LG Chem America did not sell those cells to any of them.
But LG Chem, with knowledge that those batteries were finding their ways into vaping devices and exploding in 2016 made efforts to add warnings. They made efforts to make these batteries safer. And if they made those efforts with that knowledge, and I think that there was evidence that they were, facing lawsuits all over the place, and they kept selling. They kept selling them and selling them, selling. Once you know that they're being used for that purpose, even if you didn't initially supply them for that purpose, how is continuing to sell them and sell them and sell them and even make modifications that take into account that misuse somehow mean that you can't be held accountable?
Judge Min, because I don't want to go too far into the seal, but if you look, they took extreme measures, as indicated in exhibit on page 15 and 16, to interrupt that supply chain that you're discussing. And so I can't go into it since we are now on live, but in that
Yes.
sealed record, there were efforts to stop just what you're talking about. And that goes back to who's the consumer.
So do those efforts stop personal jurisdiction prospectively?
Well, those were done before, if you look at the timing, they were done before Mr. Miller ever bought anything. And it goes back to what I want to talk about. So if you look under our long arm statute, it talks about under 1-75.4, it talks about how do you get there. And it talks about, when talking about products and materials, it talks about products and materials and things processed and serviced or manufactured by the defendant or used or consumed within the state in the ordinary course of trade. Now, I would argue that this was not the ordinary course of trade. This is not to whom we were selling them for. Limitations were put on their sale, but they still got here. So maybe even our long arm statute doesn't get there. But the other thing is that all these talk about the consumer. This was not the consumer of our product. As the trial court found, this is not who these were designed for. This was not a standalone cell. This was sold to be packaged. And that's who the consumer was. The consumer were these people who were then going to turn these into power packs for, my weed whacker or my power drill or those kind of things. These were misused and sold without the permission of LG Chem America. So going back, Your Honor, Judge Tyson, to the conversation about are we stream of commerce plus, or where that limit is, I think we have to look at the decision of Ford. Because what were they looking at Ford? Because clearly we were talking about two very specific.
Is stream of commerce plus, is the purposeful availment the plus?
I think purpose availment, but I imagine it depends on the case. In Ford, when you're talking about a product, the plus was they said,
They're everywhere.
No.
They're ubiquitous. That's basically what they're saying about Ford. You are everywhere selling. You got licensed dealers in every state. You promote these models in every state. Ford is a different animal than.
But I somewhat disagree with you, Your Honor, very respectfully, is they focused on the Crown Victoria and the Explorer. And they talked about you market these in this state.
In both the states, Minnesota, right.
Because I want to stay away. I do not believe that we are a nationwide, right, that there's a nationwide personal jurisdiction. I think the courts have said that's not where we are. I think where we are is in Ford, they didn't talk about all the cars Ford sells, right? And I think that's important in this case because the other contacts that the plaintiffs talk about the other things that LG Chem or LG Chem America might have done in North Carolina, that's not the 18650 cell. Those are different things, and I think that's important to point out. The Ford case was about the Explorer and the Crown Victoria.
So my point is this. I think Ford, there are not many Fords. There may be IBM, there may be Amazon, you could probably name 10 corporations that are ubiquitous like Ford, okay? So there's a standard less than that, and Justice Kagan said related to with real limits. I'm just trying to get some understanding of what your understanding is of what she meant by that and how it applies to you.
I don't think it applies to us all because we have not personally availed, or LG Chem and LG Chem America have not personally availed themselves of the North Carolina market for the selling of these 18650s.
So that's why it's not related to.
Absolutely. And that's when you asked me before, Mr. Darrenbacher, do you think that the law now is related to? My answer was, I don't think it matters because I think there is a lack of personal jurisdiction in this case regardless.
But
whether that's LG Chem or LG Chem America.
Would you agree that you can show personal jurisdiction in a matter in addition to a but-for, a causation?
I wouldn't agree, but I think that's what Ford is saying. Yeah.
That you can show personal jurisdiction without a but-for causation.
I don't agree, but I think that's what the
I understand
majority
you don't like
opinion.
it, but
I think the majority opinion is deciphers, and I think in the Cohen case there was that discussion as well. But I think it was easy in the Cohen discussion because in Ford they talk about the dealerships in Minnesota and Montana. They talk about the advertising in both. You go to your Cohen case, they say the same thing. They say that it was all those keys of being, there was a Triad was a distributor, Air Care was a provider, and they had the service manual. That's that whole stream that goes right into North Carolina.
So that goes to the purposeful availment? Is that why Continental, quote, purposely availed themselves of North Carolina?
I think that's how they're related to, they're related to.
That-
I think that's what, I don't have Cohen right in front of me, but my recollection is that the court was dealing with this new standard of related to, and they said, this is how it's related to. That's my recollection of that opinion, Your Honor.
And it was related to by virtue of a purposeful availment.
Of that product.
Right.
And again, I think that's what we have to go back to. That's where your limit and your sphere is. It's not that you purposely availed yourself, again, LGA Chem America. The trial court said LG Chem America sales in North Carolina are limited to petroleum chemical products. I do not believe that LG Chem America purposely availed themselves to be sued with regard to 18650s, because in there it says these sales have no relationship to the distribution of 18650 lithium-ion cells for sale in North Carolina, consumers to use electronic cigarettes or vaping devices.
if they purposely availed themselves so that there is personal jurisdiction to sue them over the 1850s generally, and then you have a misuse that they know about, how is that not related to the batteries that they've been sending into North Carolina?
A misuse they know about, you're saying that people are misusing this product even though that, as is indicated in affidavit 1516, wanted to prevent.
Well, and there is a deposition from another case in the record at pages 189, 190 that talks about after learning of the vape pen fires, they reduced the thickness of the batteries to diminish the risk of fire. I appreciate Judge Tyson's point that that might be in general, but they didn't modify these batteries to make it so they wouldn't work with a vape pen, right?
Well, as a finding of fact in this case, there are legitimate business reasons. This is finding of fact number 7. And again, I want to go back to that. These are competent findings of fact. And this is, I hate telling judges what they're bound by, but those are the findings of fact. And the finding of fact is there are legitimate business reasons for the design of LG Chem's 18650 lithium-ion cells in such applications which render the cells inappropriate for use as standalone replaceable rechargeable batteries. So
you're saying the vape manufacturers made the vape machine to conform to the battery, not the battery to conform to the vape machine?
oh, absolutely, Your Honor. As in that,
And
Judge
you're
Inman, in
you're
that
saying that's
same...
not LG's fault, the fact that someone designed their mechanical device to misuse.
Right, and then as on Affidavit 1516, talk about the way we need to deal with that. And if you read that same deposition, Judge Inman, somewhere in there he goes, we never fathomed that this would happen. When they built these things, they're supposed, and again, the reason why there's cells, and I don't know if this is record, but the cells, they get packaged together. And depending upon how much power your item needs, that's how many cells you put together. And they're all nicely wrapped up, and there's wires going in. It comes out like that. This was never intended to be a standalone product. It's a component, and it's a component that somebody is misusing, and LG Chem did everything possible along that distribution chain to stop that from happening.
Let me ask you this. If once they knew that unauthorized distributors were selling these, and I don't want to go too much in the record, but it looks like that the unauthorized distributors to the vape shops came through China. There's evidence in the record that showed that the distributors to the vape shops were distributing these batteries through China. Does LG, to avoid liability or avoid jurisdiction, are they obligated to close those illegal channels? Or to, once they know about them, are they under some obligation to affirmatively try to prevent that from happening?
Two things. I won't dispute with you if I don't recall that in the record. I do, but what I will say is that I don't know if they have an obligation, but if you look at...
What they're saying they're not authorized, and they know that this happens, it's like piracy, it's like Confederate goods or counterfeit goods.
Well, it's not ordinary trade, as under the long-arm statute talks about 1-75.4, this is no longer ordinary trade.
So that's back to your argument that we don't even get to the constitutional issue because it's not within the long-arm statute.
Yeah, that only comes about because of the discussion about the products. In all candor, that's not in my brief, but when brought up that's in the Cambridge case that we brought up a moment ago.
But if 80 vape shops in North Carolina are selling it, it seems rather ordinary. I mean, doesn't sound so rare. Can I ask you just to switch gears and to talk about the discovery, the issue? Because as I understand the plaintiff's argument, and you mentioned that Georgia has a very different burden of proof. Tell me if I'm wrong about this. My understanding is the allegations in the plaintiff's complaint are taken as true. The defendant asserts there's no personal jurisdiction. The defendant presents some evidence to refute the plaintiff's allegations, and you have affidavits here. Is it that then the burden shifts back to the defendant to establish a prima facie case?
Your Honor, so our case law has the same paragraph that goes into almost all of these decisions that talk about that, and it talks about the trial court can do three things, one of which just have the motion to dismiss, and then the plaintiff has to rebut it. There can be affidavits, or there can actually be a hearing.
With testimony.
Right. What we had here was, I think, a hybrid of that, because we had affidavits. The court then allowed the parties to supplement their presentation at the hearing by way of the materials that were submitted by plaintiff and the...
But the plaintiff couldn't supplement with any discovery from your client. The plaintiff is arguing that these defendants who are saying there's no jurisdiction have the exclusive access to the information that we need to show our prima facie case.
I will make two responses to that,
Sure.
Judge Emmett. These clients did answer discovery. They have just objected to the breadth.
I read them. I read them.
There was an
I read the
answer.
objections.
And then, so there was, because they were overly broad requests, there were answers in there. The second point is the one that, the softball you threw me by saying, couldn't you have just moved to compel? They noticed the motion to dismiss hearing. No, I'm sorry, not sorry. The plaintiff appellants, they noticed the motion to dismiss. It was pending. We had preserved that, but they are the one who noticed it for hearing. It was argued.
They also noticed their motion to compel, but is it your argument that, A, you got out-lawyered,
No,
basically?
no. I would never claim to outlawyer anybody, Your Honor. But what I'm saying is that jurisdictional discovery is not a given. But in this case, we answered discovery that we felt was limited to the discovery issue that didn't get into merits. One of those questions say, identify all contacts you've ever had with North Carolina, not specific to 18650 batteries, not limited in time or space. It was a valid objection. So, Your Honor, that's what I would say. I would say is that based upon the timing, it was appropriate for the trial court to rule on the motion to dismiss, and based upon the findings of fact, it was the right decision to dismiss plaintiff's claims for lack of personal jurisdiction.
I want to ask you a question on that I will certainly ask plaintiff's counsel too. Did we not review that ruling under abuse of discretion standard?
Absolutely, Your Honor. Yes, that's.
So the discovery request, basically, we give deference to the trial court.
Yes, yes.
If this panel were to disagree with you and to overturn the granting of the motion to dismiss, I know that's unimaginable, but if that were to happen, what would be the reason not to allow further jurisdictional discovery to resolve this dispute?
Well, it would require you to do two things. It would require you to, one, make a decision whether or not the findings of fact were competent. And again, that standard is a reasonable mind might, right? That is I don't want to say it's as low as abuse of discretion, but that's a really low standard. That means that you basically have to say the trial judge could not have done that with reading what he read.
And it's your argument that, of course, that the findings of fact, if they are all found supported by competent evidence, they support the conclusions of law, and there's no ifs, ands, or buts about that. It's not possible that the findings of fact are all supported and that the conclusions are not.
I agree 100%, Your Honor. That's not what the plaintiff appellant says. Plaintiff appellant says is that these go to the merits. They don't go to the jurisdictional issues. But that's where I wholly disagree, because they want to say, oh, you didn't make an effort to keep it out of North Carolina. We tried to keep this out of everywhere.
So the conclusions of law would be reviewable de novo. You
Yes,
do
Your
agree
Honor.
with that?
Case law, yeah. The case law, I think that's in the openings of both my brief and opposing counsel. I think we both agree on that aspect of it.
So you only have I'm going to withdraw the question to give you time to close. I'm sorry.
Thank you, Your Honor. Well, like I said, Your Honor, I'd like to clearly point out that I think that the standards articulated in Ford, whether that's the new law of whether it's doing away with the but-for or whether it's now the related to, I don't think the standard matters. And I think that as the court identified in the Cohen case that you were on, I think it clearly articulates that in this scenario, whatever that new standard we want to call it, it's not in this case. And that the trial court was correct in their findings of fact and their conclusions of law, and determining that both LG Chem Limited and LG Chem America's motions to dismiss should be granted. Thank you for your time.
All right, thank you. And rebuttal?
you. The first issue I would like to address is council's statement that LG Chem took extreme measures or everything possible to prevent the sale of these batteries for use in vaping devices. The court can, of course, review the sealed materials, but plaintiffs submitted an affidavit, which the trial court considered, where a member of the plaintiff's team found that over 100 vape shops in North Carolina sold LG Chem 18650s for the use in vaping devices. That affidavit was made in 2020. So when LG Chem had notice in 2016 and could have prevented the sales for vaping devices, by 2020 they're still available in over 100 vape shops in this state. Next, I'd like to speak about Cohen because I didn't get an opportunity to, and I think it's very important. In Cohen, personal jurisdiction was decided on a preponderance of the evidence standard. It wasn't this initial standard of prima facie case, which is all the plaintiff has to show here. It was decided after years of litigation and exchanges of discovery. The court even allowed additional jurisdictional discovery after the motion to dismiss hearing. And because of that, the trial court and this court, when it reviewed it, it understood that CMI's business model was to sell aircraft engines and components nationwide through distributors. Here, Mr. Miller is simply asking for the same opportunity that the Cohen family had for discovery related to the defendant's business model, which we know involves distributors and contacts in North Carolina.
Ms. Willingham, I asked the same question I asked of defense counsel. How do we review the trial judge's ruling on discovery matters?
It is an abuse of discretion standard. I agree with that.
That's a high standard in North Carolina, isn't it?
It is, but I believe that it is appropriate in this case to find that the trial court abused his discretion. Let me find my reasoning on that.
While you're looking for that, how do you respond to defendant's assertion that they did not stonewall you on discovery? They actually they responded to your discovery request.
I disagree. They objected. If you call objections responses, there's two instances where they actually gave a substantive response. LG Chem admitted that it didn't have contracts, documents, or agreements before the plaintiff's injury restricting the sale of 18650s to North Carolina. And LG Chem America admitted to assisting distributors in Texas and Illinois in selling 18650s, but they did not provide the names of those distributors or any other information from which plaintiffs could present the court information. About the abuse of discretion, the affidavits that the defendants have submitted are misleading at best, and I believe that is why the trial court abused its discretion. It relied on those affidavits and these objections and incomplete discovery. In fact, when LG Chem America first moved to dismiss this case, it claimed it had no business in North Carolina. And when the plaintiffs presented evidence that it was actually registered with the Secretary of State to do business, it changed course and admitted to primarily selling petrochemicals in the state of North Carolina. When asked at the hearing by the trial judge what are petrochemicals used to make, counsel for LG Chem said he did not know.
Any further questions? Okay.
The plaintiff would ask that you reverse the finding on jurisdiction, or if not, allow for jurisdictional discovery. Thank you.
Right. Thank you very much for your arguments.
All rise.
Thank you for your arguments.
This session of the North Carolina Court of Appeals is adjourned.